Hello, I am Dr. K.K. Misra from our classes. In series of presenting video lectures on Indian legal system through this video tutorial today, I am going to talk about Indian judicial system. The three-tiered system of Indian judiciary comprises of Supreme Court, that's in New Delhi, at its helm, High Courts standing at the head of state judicial system, followed by district and sessions courts in the judicial districts into which the states are divided. The lower rung of the system then comprises of courts of civil, judges and criminal, judicial, metropolitan magistrates jurisdiction. The Indian judicial system is a single integrated system. The Constitution of India divides the Indian judiciary into superior judiciary, that is the Supreme Court and the High Courts, and the subordinate judiciary, the lower courts under the control of the High Courts. The Supreme Court of India is the apex court of the country, as we all know, and it is located in Delhi. It sits in New Delhi. It is presided by the Chief Justice of India. There are 24 High Courts in the country. Each state has one High Court, although some of High Courts have jurisdiction over multiple states and union territories. For example, the Guwahati High Court exercises jurisdiction over the states of Assam, Nagaland, Mizoram and Arunachal Pradesh, all of which are situated close to each other in the northeastern part of India. For administrative convenience, states are further subdivided into districts, each of which has its own district court. Barring a few states, the original jurisdiction for both civil and criminal cases vests with the district courts. The judicial system also consists of tribunals and commissions which are established under and to deal with specific statutes. On the 28th of January 1950, the Supreme Court came to be. The judges of the Supreme Court at the time of inauguration were Chief Justice Harilal J. Kania and Justices Syed Fazal Ali, M. Patanjali Sastri, Meherchand Mahajan, Bijan Kumar Mukherjee and S.R. Das. The first Attorney General for India was Mr. M.C. Setalwar. The Supreme Court of India comprises the Chief Justice and not more than 25 or even 30 other judges appointed by President of India. Let me tell you here that now the current strength of the Supreme Court has been extended from 30 to 34 as per the recent amendment of Parliament. The proceedings of the Supreme Court are conducted in English only. The registry of the Supreme Court is headed by the Registrar General. The Attorney General for India is appointed by the President of India under Article 76 of the Constitution. Three types of advocates: senior advocates, advocates on record, and other advocates normally practice. India is a federal state having a single and unified judicial system with three-tier structure, that is, Supreme Court, High Courts and subordinate courts. The Indian Constitution under Article 124 Clause 1 states that there shall be a Supreme Court of India consisting of Chief Justice of India and 34 judges, including the CJI. The jurisdiction of the Supreme Court of India can broadly be categorized into original jurisdiction, appellate jurisdiction and advisory jurisdiction. So here in all, the maximum strength of the Supreme Court shall be now 35, including Chief Justice of India and other 34 judges. But at present, including Chief Justice of India, the strength is 34. Supreme Court at the apex of the Indian judiciary is the highest authority to uphold the Constitution of India, to protect the rights and liberties of the citizens, and to uphold the values of rule of law. Hence, it is known as the guardian of our constitution. The Indian Constitution provides for a provision of the Supreme Court under Part 5th, the Union, and Chapter 6 titled the Union Judiciary. The Constitution of India has provided an independent judiciary with a hierarchical setup containing high courts and subordinate courts under it. As mentioned earlier, here Article 124 Clause 1 and Amendment Act of 2008 states that there shall be a Supreme Court of India consisting of a Chief Justice of India and 34 judges including the CJI. Article 124 Clause 2 states that every judge of the Supreme Court shall be appointed by the President of India by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Courts in the state. Now, about the High Courts. The High Courts are generally the last court of regular appeal. Besides, for invoking writ jurisdiction, the High Courts can be approached for enforcement of other rights. As far as writs are concerned, this will be explained through other video tutorials. It has the power to supervise the subordinate courts falling within its territorial jurisdiction. The High Courts are courts of records. The High Courts also exercises original jurisdiction under the Companies Act. The High Court hears first appeals from the decisions of the district courts. Section 100 of the Code of Civil Procedure provides for a second appeal from appellate decrees. Under Section 115 of the Code, the High Court is conferred with revisional jurisdiction. Under Article 227 of the Constitution also, the High Court in the exercise of its powers of superintendence entertains revision petitions to correct errors on the part of lower courts and tribunals in judicial and quasi-judicial matters. On the criminal side, the High Court has to confirm all sentences of death passed by courts of sessions and hear references in this behalf. High Court hears criminal appeals from convictions awarded by sessions judges and additional sessions judges or from the judgment of any other court, where a sentence for more than 7 years imprisonment has been passed. The High Court is also empowered to entertain appeals from orders of acquittal passed by any court. High Court has also been conferred with criminal revisional jurisdiction. Now, the subordinate courts. The subordinate courts are A. District courts empowered to hear appeals from courts of original civil jurisdiction besides having original civil jurisdiction. B. Sessions court is courts of criminal jurisdiction having the similar scope of powers. The courts of specific original jurisdiction are courts of civil judges, of judicial magistrates, small causes courts and courts of metropolitan magistrates. Quasi-judicial system. This appendage to the Indian judicial system is a recent and sincere attempt on the part of the government to expedite the judicial process through dilution of procedural formalities and avoidance of litigation. Tribunals form an indispensable part of this system, which are appointed by the government and comprise of judges and experts on the particular field for which the tribunal has been constituted. Also, legal education, though new education policy has been introduced that will be discussed in other video tutorial, but here at present there are two educational options for would-be law graduates in India. Specifically, I am telling one is of a 5-year program to which one can be admitted after passing a school leaving examination taken after completion of 10+2. The other is a 3-year program available only to those who have already graduated with a degree in arts, science and commerce. This was a simple information related to legal education. So this was all about this video tutorial on Indian judicial system. This is given in brief. I hope that this will act for you as a ready reckoner and you will like it. If you like it, please do not forget to subscribe my channel and press the bell button and pass it on to others, those who are needy now and in the future. Thank you. Please like, share and subscribe. Thank you very much. Have a nice time. Best of luck.